Hello, my name is Lisa Sumner, and I am a member of the Creditors' Rights team here at Nexsen Pruet. In this video, I will talk about how farm credit associations should handle patronage refunds when your borrower is in bankruptcy. A member's bankruptcy should have an effect on the member's right to receive a patronage refund, but the precise effect depends on variables in each case. Let's examine a few of those variables. The first question to ask is whether the member who is in bankruptcy is eligible for a patronage refund. Look at what your association's bylaws and policies say about patronage eligibility. For example, some associations exclude borrowers from patronage eligibility if they have an accelerated loan, a loan in default or non-accrual and past due at year end, or if any portion of their debt to the association has been charged off in the past 7 years, or if the member waived patronage rights in consideration for a forbearance or restructure agreement with the association. These types of eligibility rules often apply to a member who is in bankruptcy. In addition, some associations make bankruptcy itself a disqualifying condition. For example, a member may be ineligible if they filed a voluntary bankruptcy petition or had an involuntary bankruptcy petition filed against them within the past 7 years. If your association does not have eligibility rules like these in place, perhaps it's time to consider adopting them. If a member who is in bankruptcy is eligible for a patronage refund, the next question to ask is whether the association has a right to retain that refund. An association might have a right to retain a refund if the association obtained a lien on patronage refunds, or if the association has a right of set-off against any refunds. You'll need to consult with the association's legal counsel to determine whether such liens or set-off rights exist in a particular case, and how they can be preserved during a bankruptcy case without violating the automatic stay. Here's some general guidance. The automatic stay prohibits collection action without court permission after a bankruptcy filing. During a bankruptcy case, the association should not enforce a lien or set-off rights against patronage refunds by applying them to the debtor's outstanding debt without first obtaining relief from the automatic stay. Violations of the automatic stay are punishable through court-imposed monetary sanctions and disallowance of claims against the debtor. An association can place a temporary administrative hold on patronage refunds while seeking relief from the automatic stay, but should not use such holds as an excuse to hold a patronage refund indefinitely. Let's assume you have determined that a member who is in bankruptcy is eligible for a patronage refund, and the association has no right to retain it, or chooses not to retain it. To whom should you disperse the refund? In certain chapters of bankruptcy, a trustee is appointed, and the trustee may have the right to receive and control use of a patronage refund. An association can find itself in the middle of a dispute between the trustee and the member in such situations. So you should be wary of distributing patronage refunds directly to a debtor during a bankruptcy case when a trustee is in place. If you have any questions or need more information, please call me or any of the other members of the Creditors' Rights team here at Nexsen Pruet.